Okay, we're going to go ahead and get started. I'd love to start off first by introducing myself. My name is Jocelyn King. I'm the CEO and founder of a company called Virgil HR. We're an employment and labor law compliance software, and our software does a number of things, but really what we're here to do is help save HR time, bring a sense of confidence when they're making compliance decisions, and reduce the need to speak to outside counsel as often and mitigate risk along the way. And we do so by offering a smart chatbot that analyzes what federal, state, and local employment and labor laws apply to day-to-day tasks you're working on, eliminating the need for you to do any research. We have a host of other tools, including an employee handbook builder, legal updates, and the ability to speak to an attorney. I've been in the HR space my entire career before starting this company. I've worked with very large public companies, small private companies. So I've had a ton of experience, unfortunately, I guess, with workplace investigations, and I'm excited to talk about it today. And I'll hand it off to you, Audra.
Yes, thank you, Jocelyn. Hi, everyone. My name is Audra Hedberg, and I will be jointly presenting our session today with Jocelyn. I have also been in HR for several years, over 19 years, really focusing my efforts mostly in employment law, compliance, employee relations, and workplace investigations. I am currently the VP of Services for Troop HR. And for those of you who may not be familiar with us, we are a human resources company that loves to help our clients thrive by providing a full spectrum of HR services, including full HR outsourcing, consulting services, and also e-learning solutions. We are proud to be ranked as one of Oregon and Southwest Washington's top 100 fastest growing companies and top women-owned companies. And however, even though that's Oregon and Washington, we do serve clients throughout the United States.
Great. Well, we're really excited to have you, Audra. Thanks for
Thank
joining.
you.
Yeah, so really quickly before we begin, just want to bring this disclaimer. This webinar is intended for education purposes and shouldn't be considered legal advice. So if there are decisions that you need to make, actions that you need to take, make sure it's not based solely on what's shared here with our webinar content. You should absolutely engage with an attorney. So we'll move into
Yes.
the agenda. We'll first talk about the legal framework, the types of workplace investigations you might encounter, planning and conducting the investigation along with post-investigation work, and then some case studies Audra and I wanted to share, followed by Q&A. So what I'd ask is along the way, if you have any questions, please go ahead and submit those questions in the Q&A section, not the chat section, if you would. That way we have that pulled up and we're ready to get engaged with these questions as soon as we get to the Q&A section.
All right. Well, I am going to kick us off with the legal framework. So just a bit of background on why this is important, and we're going to go through some different definitions here. So all right, so let's start with the framework here. So harassment, discrimination, retaliation, prevention in general is really, really critical. These concepts are in creating that safe and inclusive workplace environment. Yes, I know these are all legal terms. They can feel a little scary. But I'm going to break them down here in a bit so they don't seem as scary or intimidating. So let's start with the Civil Rights Act. So Civil Rights Act of 1964, specifically Title VII, which involves employment. This was our landmark legislation in 1964 that protects employees and also applicants from harassment, discrimination, and retaliation based on protected classes. Again, this is a federal law still in effect today. So let's break it down. So what is harassment? So again, a big legal term, but it really just refers to any unwelcome conduct that is based on, again, that protected characteristic or that protected class or protected activity. So federally, we're talking about race, gender, age, religion, disability, sexual orientation, nationality, pregnancy. There's other protected classes. So at the federal level, I do want to point out, and I'm going to get to a bit of this more when we talk about state-specific laws, is that the list of protected classes at the state level is much, much longer, especially if we are dealing with the West Coast and the East Coast. West Coast and East Coast employment law, very, very progressive. Oregon, Washington, California, New York, Massachusetts, Connecticut, Vermont on the East Coast, very, very progressive. We are seeing Colorado and Illinois also start to become a bit more progressive. So please keep that in mind. That is not an exhaustive list, that there's much more at the state level. So harassment can take various forms. It can include verbal, physical, visual behavior that it creates what you've probably heard, a hostile work environment, an intimidating work environment, or an offensive work environment for the victim or for the complainant. But again, it has to be based on that protected class or that protected activity. So some examples could be, offensive jokes, derogatory comments, unwanted touching, or threats. Moving on to discrimination. Discrimination occurs when you have an individual, an employee, an applicant who is treated unfairly or just treated differently based again in their membership in that protected group. So this can involve decisions, what I call employment decisions. So this could be actions around hiring, promotion, compensation, termination decisions that are influenced on biases related to those personal characteristics. Again, federal level, we're talking race, gender, age, religion, disability, sexual orientation, pregnancy. Discrimination can be very overt, or it could be really, really subtle as well. And then we have retaliation. So retaliation, this occurs when an individual faces some sort of adverse consequence, adverse action, or treatment as a result of them invoking their rights into a protected activity or because of their protected class. So this could be things like because they reported harassment, because they reported discrimination, or other types of unlawful activities in the workplace, that they're now being treated differently, or there are consequences against them for doing that. Retaliation is the most common complaint filed generally year to year with the EEOC. This is the Equal Employment Opportunity Commission. And we always get this question, well, why is that? Well, retaliation is it's human behavior, right? Somebody complained about me, I'm really mad at them, and I'm going to get back at them. That is retaliation. That's generally why this is going to be the number one claim that's filed. So again, this could include actions such as demotion. It could be reassignment. It could be termination. It could just be ostracism by a colleague or a manager. They're treating them differently. They're not saying hi to them in the morning. It could be as subtle as that. It is illegal, and retaliation does come up quite a bit during workplace investigations, especially with that responding party, that person who the complaint is against. We'll talk about that here in a bit. All right, state-specific laws. So again, just please familiarize yourself, especially if you're a multi-state employer, with the specific requirements around what's required for workplace investigations. I'm not going to be able to get into every state today, but I just wanted to give you a few examples. So California is the most litigious state in the country. Lots of lawsuits, class action lawsuits going on there. California has the Fair Employment and Housing Act, or FEHA, and also the California Civil Rights Department. And this law requires employees to take all reasonable steps to prevent and promptly correct any discriminatory or harassing conduct. Also in California, employers must conduct a fair, timely, and thorough investigation and reach reasonable conclusions based on the evidence collected. So very, very specific requirements in California. Also in California, they do require employees and managers to go through sexual harassment training. So any employer in California, 5 or more employees, needs to take that training. New York, for example, so New York human rights law, very similar to California's law, but it does require employees to prevent and address harassment and discrimination in the workplace. You also have to have a policy in New York. And also the policy in New York is a little bit different than the policy that's required in New York City. So just something to keep in mind there, and very, very specific details that need to be in those policies. Like California, New York also has that mandatory anti-harassment training. Finally, my last example here, Illinois. Like I said, Illinois is becoming more progressive. They have the Illinois Human Rights Act, again, prohibits discrimination in the workplace. All employers have to take reasonable steps to prevent harassment, discrimination. They also have Workplace Transparency Act. This actually requires employers to report to the state the specific numbers of adverse actions or judgments against them on a yearly basis. So you actually have to report that to the state. Also, like California, New York, there's training requirements and separate training requirements for the city of Chicago. Okay, so what happens? What happens if you don't properly conduct an investigation, take proper action? you don't follow these laws, well, a lot can happen. The biggest thing that can happen is a lawsuit, class action lawsuit. You could have fines, penalties, legal liabilities. Not to mention, this is very damaging to your reputation as a business. Could also affect the financial stability of your business. Legal claims, lawsuits, class actions are so expensive, and they're very, very disruptive to an organization. So you could have back pay, front pay, emotional distress damages, punitive damages, not to mention those pesky attorney's fees. So I have actually seen companies go bankrupt because they didn't document, break and meal periods. They didn't document, an investigation properly. They had some missteps in investigation, didn't take proper action, didn't put mitigating measures into place. And it was really, really sad to see that they went bankrupt. So this is why this is really important to get this right. So again, why does it matter? Well, like I mentioned, this is your brand, your reputation, your brand image. Anybody can go out there today and read your Glassdoor reviews. Having negative employee relations can really also attract media attention. If you have a lawsuit, class action lawsuit, you really don't want to be in the news there. That's going to in turn affect your reputation. It's going to affect your recruitment efforts. It's going to affect employee morale. Employees don't want to work for companies that are getting flooded with lawsuits, or just employers that are not well intended and doing the right thing. It's not going to appear well for your clients, your customers, or even your potential customers who can go out and read all of this or see the next news story. Your employee morale, it can definitely affect your employee morale. So having, again, that trusting, transparent culture, that's going to lead to higher morale, engagement, employees feel comfortable bringing complaints forward, things are addressed. Again, companies that are wrapped up in nonstop complaints really shows that the company's not taking proactive steps or addressing issues as they come up, which leads to happier employees, right? You've got good employee morale, you have happier employees, you're going to have increased productivity, which is really going to directly affect a strong bottom line. Higher retention in your workplace, in your workforce. You're going to have less turnover, you're going to have increased engagement. Again, it goes hand in hand with having those happy employees, going back to being that really good, ethical, caring employer who is doing the right thing. And then reduce costs. So you heard me talk about the fines, the legal fees, attorney's fees, but those are the costs that you can really see. But the other costs are your turnover cost. It costs a lot of time and money to recruit people, to train them, and you have that constant turnover. It leads to really higher costs. Again, so reduce costs, higher productivity. You're going to have more innovation. It's a win-win for both your employees and your organization. All right, so let's start with what are employers required to do. Again, this is not an exhaustive list, but I wanted to run through the main points here. So number one, act promptly. If you have an employee complaint, an employee has come forward, really important to act as quickly as possible. And I get this question a lot from clients. Well, what do you mean? Like, how quick do I need to do it that day, the next day? I mean, the best example I can give you is, let's say you're an HR department of one, and you're responsible for running payroll. Payroll is due by 5 p.m. that day, the same day that you received the complaint. Your employees need to get paid. Process the payroll, then start that investigation. Get help if you need it. And it's really, again, it's important to act promptly. But if you don't have the time, you don't have the resources or the team, or gosh, you're just not sure where to start, get some help. Look to a third party, somebody who can help you get going on that investigations. We know investigations are super, super time consuming. They are complicated. It's a winding road depending on the situation. So again, if you aren't able to get these completed as soon as you can, or if you're just not quite sure, or there's a conflict, which I'll talk about in a bit, it's good to get that outside third party. Stop the harassing behavior right away. This is really what I'm talking about here: managers, supervisors, leadership, HR employees, even bystanders. If you see something happening, hear something, as a representative of the organization, as a manager, HR employee, you need to stop that employee, that behavior right away. Don't ignore it. Don't walk away. Don't turn your head. An example I can give you here, let's say you have somebody, walking, from their car to into the office, and you hear and see an employee make a cat call at this female employee. Stop it right away. Approach that employee. What I just heard, what I saw was inappropriate, and you need to stop that behavior right away. And then you need to report it, which is my next point. I just want to make a note here when I'm talking about managers, supervisors, leadership employees. You are representatives of the company. Management can be sued personally. They can be personally liable if they are not taking action. If they heard something, saw something, they received a complaint and didn't do anything with it. I have seen this happen. I have seen executives, leadership named in lawsuits where they're personally liable. So again, just be careful there. That's why it's important to take all the right steps. Then report it. You saw what happened, go report it. Report it to your HR team, whoever that is, who is responsible for conducting that investigation. Confidentiality. So confidentiality is very, very important through the investigation process. However, it's extremely important to know that it cannot stay just 100% confidential. It needs, if an employee comes to you and say, this needs to be confidential, can you just keep that between you and I? It depends on what you're going to tell me, but if it's something that requires a mandatory report, I have to report it. So, the best thing to do is to let the employee know we're going to keep this as confidential as possible. Only those who have a business need to know will have information about this investigation. And my advice to you is keep that circle small. Only maybe it's the complainant's manager, the HR person who's doing the investigation, and whoever is making that decision from the outcome of the investigation. Keep that circle really small. Hold those accountable. If you go through the investigation process and there are findings that this behavior did occur, take care of it. Hold those accountable. This could be, corrective action. It could be separation. It could be more training. There's lots of different ways to correct the behavior. If you don't do that, again, it can lead to legal claims, lawsuits. It also will affect your credibility as a leader or an HR professional if you don't do anything about it. And then implement those mitigating measures. So again, if there are findings, make sure they are addressed with that responding party. Again, corrective action, final written warning, policy enforcement, more training. If you see, gosh, I need to update my policies as a result of this, update those policies. If you determine, gosh, I need to train my entire workforce or retrain my workforce or retrain the specific team, do that, document it. Do what you need to do to ensure that this behavior doesn't happen again, or it's not perpetrated throughout the investigation or through the company. The EEOC and the state level agencies, they look for this. They want those well-intended employers who say, oh my gosh, I saw this issue, didn't know what's happening. I did an investigation, I corrected the issue. And oh, by the way, we did all of this training. We implemented our policies. We're taking care of things as they come up or if they come up. We're holding those accountables. They want those well-intended employers who are making those really good faith efforts to stop any potential repeated behavior. All right, so let's move to employee rights. So first of all, to take a step back a bit, really encourage leaders, managers, HR employees to model that inclusive, have that respectful workplace, because you want employees to bring complaints forward in a safe environment. I will tell you the last thing that you want is an employee to be scared. They're scared of retaliation. They're scared of what might happen to them. So they don't report it, and instead they go around and they get an attorney. You want to handle your issues internally before they go to an outside party. So our managers, supervisors, they play a big role. They're setting the tone so that employees feel safe to go and make those complaints. Rights to be informed and confidentiality. So again, really, really important to acknowledge the complaint. And my spiel that I usually say is, thank you so much for bringing this to our attention. We take this very, very seriously. There will be absolutely no retaliation for you coming forward. Here's a copy of our anti-retaliation policy. Here's how we're going to conduct the investigation. Please know that we are going to keep this as confidential as possible. If only those, again, who have the business need to know are going to have information around this. If you ever feel like you may be retaliated against, something is going on that makes you feel uneasy, come see me. Come see me. I am your contact. Um, Also, we'll be conducting the investigation just as soon as possible. I will give you periodic updates. But if you ever, want to know where we're at, please come see me and I will give you an update. Especially, it's important with the updates, especially if it's going to take longer than you anticipated. That just helps them to know that you are taking care of what their concerns are. Fair treatment, and also an impartial investigator. So, of course, all employees should be treated fairly, equally, consistently, and that investigator needs to be impartial, unbiased. There should not be any sort of conflict of interest. If any of those things are occurring, you really need to get an outside third party to do those investigations for you. Or if you're like, gosh, I have so many investigations and this keeps coming up, I don't have the resources or the team to do this, or maybe they're not skilled to do this, or maybe you found yourself where you had some missteps and you found yourself in trouble, it may be easier just to offload those investigations to an objective third party. Protections from retaliation, we've talked about this, there'll be absolutely no retaliation. Important to explain that to the complainant, also to any witnesses that you are interviewing. Witnesses can be scared. They can be scared to give information. They don't want to get in trouble either. So it's important to talk to them about anti-retaliation. But really, most importantly, is to really drive home the anti-retaliation speech to the responding party or the person who the complaint is about. That is where the concerns are, because that is generally, this employee is like, oh my gosh, they complained about me, how dare they, I'm going to get back at them. So I give them a copy of the policy. I tell them that if we do find that there is retaliation, it will be addressed. So it's really important to be serious with the responding party.
All right, thanks so much, Audra. We'll
Mhm.
jump straight into the types of workplace investigations. So in general, there are typically 4 different types. There's harassment and discrimination. Example could be sexual harassment, like unwanted comments, unwanted touching. Discrimination could be somebody being passed up for promotion because of the color of their skin. Misconduct and policy violations, that can range widely, but an example might be, for example, violating your drug-free workplace policy, if that was appropriate for the state that the individual is in. We had fraud and theft, which is self-explanatory, and health and safety violations as well, also explanatory as well. A lot of that came up during COVID. I'm sure everybody remembers that. And so, you kind of had to handle these things delicately. So we'll jump straight into that. Planning and conducting investigations. So Audra mentioned respond quickly. Respond quickly and be prepared. That is key. The last thing you want is for somebody to come make a complaint against an individual and you sit on it for 3, 4, 5 days and they feel like it isn't being addressed appropriately. So responding quickly is really key. Then establishing a protocol, creating an investigation plan is next. If you don't have one in place, you'd put one in place. If you do, then of course you'd follow the protocol that you have in place. One of those first steps, of course, is assigning an investigator. And what's really key is that you're assigning an investigator that has no conflict, that is unbiased to the issue at hand. Of course, as Audra mentioned, ensuring confidentiality along the way is really key. Having those conversations with your witnesses, with your complainant, with the accused, is all really critical. But as she mentioned, it's important to note that there may be times where you have to say, I will keep this confidential to the maximum extent possible. If it's a sexual harassment claim, for example, and that has to be reported, obviously there are steps that will have to be taken and some people that will need to know what's going on. But what's really important in that situation is often people want it confidential because, as Audra mentioned too, they don't want to be retaliated against or they're scared of the conflict. And so it's really important to protect the complainant, but also at the same time, keep in mind that just because a complaint has been made doesn't mean that the accused is guilty. So protecting the accused is equally important as well. And then you're going to start putting together your timelines and milestones and making sure that things are moving as quickly as possible without compromising the integrity of the investigation. So when we're actually conducting the investigation, document everything. Absolutely everything should be documented. Collecting evidence is key, interviewing witnesses. When you are interviewing anybody for an investigation, you will want a written summary of their um, statement. And I always tell people as a best practice, make sure that you get some type of signature or acknowledgement from the individual that what is in the statement is correct. So by that, I mean, let's say, for example, you're meeting with Tommy Joe, and Tommy Joe has accused Sarah of doing X, Y, and Z. And he comes and tells me, hey, this is what's happened. And I say, great, I'd like you to please put together a statement, or I can help you put together a statement and then sign this for acknowledgement. What's interesting is as you get farther along and you've come up with your recommendations and you move forward, let's say that you do kind of perform some type of disciplinary action against the accused, it's also important for them to get a copy of their disciplinary findings, like a corrective action. And when providing a corrective action, making sure that you get that signature from them, not that they're agreeing to the corrective action, but that they are accepting acknowledgement that the paper was provided to them. That can be done by email. It can be done on paper. If they don't, or if they kind of refuse to sign something or acknowledge something, which is common actually, then you would just put in your notes that you did attempt to provide it to them and they refused to sign. But going back to the list, the next is analyzing the findings, of course. So in documenting everything, you're analyzing what it is everybody said. You're assessing who a credible witness is. For example, you're not leading your witnesses on in these conversations that you're having with them. And something to consider too, and it might even be at the time that you first decide to assign an investigator, is whether or not it makes sense to actually have a third party investigator come into play for this specific situation. Sometimes because it could just be a very complicated situation and you want it done right. But other times it could be because there's conflict. Like, for example, I had an investigation where I was a VP of HR and I had to investigate against my VP of engineering, who I was friends with. I felt like it wasn't appropriate for me to conduct that investigation. So I hired an attorney to come do it for us instead. So be aware of that, because what you absolutely want to avoid is bias. And when you're assessing credibility of your witnesses, you also want to consider what your credibility looks like too throughout this investigation. So that's really key. The documentation and record keeping is super important. Always remember as you're going through these investigations to consider past history as well. Somebody could already be on a corrective action for sexual harassment, and somebody's made a complaint against them again. The way that you decide to recommend your findings could be different as a result. And then communicating. And I would say don't just wait to communicate at the end, communicate with each of these individuals along the way, particularly the complainant and the accused. That's really important because you want people to feel like they're in a safe environment, that the company cares about them, that you're moving forward and you're taking the situation seriously and in a really fair manner. So, very critical. And then in terms of post-investigation, of course, we now have made our findings, our recommendations, we are implementing our recommendations. That could be, as Audra mentioned, a corrective action, a termination, it could be training, it might even be revision of a policy. But there's going to be some type of recommendation made that you move forward with. You'll constantly be monitoring compliance as well, and this can be done in a number of ways. You can use technology to do this. You can use surveys to do this. You can use one-to-one chats with individuals, but monitoring compliance is going to be really key, especially if you find that this person was in fact doing something wrong. You want to make sure that there's some type of follow-up there. Providing support to affected parties. As Audra mentioned, retaliation is a really serious thing, and it's something that a lot of people are scared about. They don't know if they're going to be treated fairly, and it's really difficult for them to come forward in that situation. So it's really important to provide support to the affected parties, not just the person who came forward as the complainant, and that's certainly really important, but even the accused as well. That person needs support. They need training. They need to if the accused was in fact found, guilty, so to speak, they need the support to correct their behavior if they're still with your organization. So don't forget about them either. And then, as part of that ongoing training program, so take a look at any state that requires compliance training and make sure that that mandatory training is done however frequently the state requires it. But you may also want to consider expanding that training to everybody in your organization and having a cadence to it. And compliance training can be really boring. So, even for us, so if there are ways that you can make it more engaging with your audience, that's always really key. And you'll find that often it gets absorbed a little better by individuals and they have a stronger understanding of what they should or should not be doing. In doing all of this, you're creating a positive work culture for your organization. And that's really key. You want to make sure people feel like there's a sense of fairness, of security, that people are treating each other nicely, that they want to be there. That impacts brand, it impacts productivity, it impacts retention, all as Audra mentioned. So that's really important. And then putting together any preventive measures or policies based on whatever makes sense for the investigation that you were conducting. So we wanted to cover a couple case studies with you. I actually have a couple case studies that I went through that I wanted to share because they were in some cases, and one of them in particular, very complicated, and so it was an interesting thing to work through, and I thought it might be interesting to you all as well. The first is theft in the workplace. This one was actually very standard. I was working for a retailer. It was one of my first jobs in HR, and somebody who was working in logistics, which is like the trucks and pushing stuff onto the floor and stuff, um, had been accused of stealing laptops from the back room. So I worked with stakeholders to gather the necessary evidence that was required. That included video footage, for example. It included witness testimonials. We had one witness that came forward, obviously interviewing the person who had been accused. This was very interesting, though, because the person who accused him was security. So the evidence was kind of already there. It made it a little easier. But because this person was so combative, by the time we finished the investigation and determined that we had enough evidence to tell us that he had in fact been stealing laptops, we were planning to terminate him for that. There was uh, a no tolerance policy for it, of course, and it was very expensive what he was stealing. So we had to call the police and have him escorted out of the building because we knew that he was going to be very confrontational at the time of termination. And I will say I have had other investigations where I've known that we're going to terminate an individual, and simply because of their personality or past behavior, we've actually had to have the police come and escort them out of the building. So something you may want to consider as a preventive measure if that is at all applicable. And then the other case study is workplace bullying. So I have a lot of examples of this, but one that I'll give is, and this was an interesting one, we had a sales development rep come forward and say that an account executive was not providing him with leads, and I'm sorry, that was not demoing his leads, so he wasn't getting credit for them. And so we did an investigation and spoke to her and found out that this entire time he'd been bullying her. And she was so mentally exhausted from the bullying that she just shut down and wouldn't speak to him anymore. And so it went from us thinking that he was in some way being bullied to actually him being the bully. And we gave him a corrective action, and he was super open to the feedback that we had to give. Completely changed his behavior, had a total turnaround, became the most productive and highest performing person on his team. And I think that that really goes to show just how important it is to um, have that sense of humanity throughout the investigation the entire time. This is not just a transactional thing. You are dealing with people and people who have emotions. And so when you can work with them and get them to that place where they still feel safe and they feel like they can thrive in your environment, then you'll see some really incredible results like his. Audra, I know you have
Yeah,
people too you wanted to share.
that's a good story. That's what you want to see, you know, and that's also why it's super, super important to interview everybody, right? Not just taking the complaint at, face value, getting all the information there, talking to your witnesses, and then getting the other side of the story. There's always two sides of the story, right? So getting the responding parties side of the story as well. But that's a good outcome. I like that one.
Thank you.
Well, mine, I'm going to talk about a sexual harassment, and maybe some of you have dealt with this. So we have an employee, let's call her Sarah. She filed a complaint with Human Resources saying that her coworker, we'll call him Mike, had been making inappropriate comments, unwanted advances towards her. So the company was like, all right, we need to investigate, we need to launch a formal investigation. So what do? Well, first, right, acknowledge the complaint, ensure her safety, the anti-retaliation provisions. You could, as a part of your process or your protocols, Jocelyn mentioned, is as part of your plan to provide her with a copy of the anti-harassment policy. You don't have to, but that's kind of a good best practice. And then we haven't talked about administrative leave. So generally, if you're going to have a serious complaint or even semi-serious like this, because we have this unwanted advances, it's very general, but it could be something serious. So I do recommend, when you have those serious complaints, that you put the responding party, the person who the complaint is about, on administrative leave. And that is really to help to protect the integrity of the investigation. When you remove that person, generally people feel more safe talking to the investigator and giving them their whole story. So in this situation, that's what we did. We gathered all the information. We started with Sarah, the who, what, when, why, where, what happened, examples. We asked for any witnesses that may have been around to see these things. Also, any evidence. Do you have text messages? Do you have emails? Is there video surveillance? So getting that. Then you're going to interview your witnesses. You're going to then interview the responding party, right? Because you want all sides of the story. You're going to review your evidence. If you need to work with IT to get things, I recommend working with IT if it's emails, text messages. Text messages can be a little bit difficult because they're generally people's personal phones, Teams messages, Slack messages, because sometimes, and I have seen this, where people will just take a screenshot of like half of the conversation, but not the full conversation. So working with IT to get the full picture, so you have everything. And I have had situations where people do just send us the screenshot, and I'm like, is that all that's there? Is there more? Yeah, that's it. And we found out that they were being dishonest, and they were actually terminated for being dishonest. You're going to review your company policies here after you have all the information and the evidence. Did this violate our anti-harassment policy? You're going to prepare a summary report. So those summary reports are really important. Keep those in your confidential investigation files. So that is, this is the complaint. This was our approach. This is who we talked to. Here's our findings, our conclusion, recommendations, if you want the recommendations in there. And then in this case, there were findings. So what we did is the comments were not pervasive or serious enough to warrant termination. We also went back and looked at his employee file to see if there's any past behavior. Has this happened before? It did not. It was a corrective act. Actually, it was final written warning, mandatory training. And he did great after that. There were no other situations or instances that occurred. Very apologetic. So kind of similar to your story there, Jocelyn. But then we did also meet with with Sarah to say, okay, thank you for bringing this to our attention. We've completed the investigation. We have addressed any concerns that you had. If anything else comes up, please let us know. But everything has been addressed. I don't recommend giving specific details as to what those actions were for the responding party. Just that it's not really necessarily, it's confidential personnel information, so I don't recommend going into a lot of detail there, but just explaining that it's been taken care of. So that one ended, it ended well. They don't all end that well. The second one is a safety one. So I worked in manufacturing environment for several years. We had an employee, we'll call him John. He suffered a hand injury while operating a machine. It did require medical attention, so he did go to the hospital. But the management team decided we need to do an investigation here, involved HR, also safety representatives. So what did we do first? First, we made sure that he, of course, received appropriate medical care, which he did. We secured the area. If this machine broken, is it going to happen to anybody else? So we shut it down. And then we notified whoever needs to be notified, safety officers, executive team, HR. We gathered the information. We talked to John, got all of his information, asked him for any witnesses, talked to those. There was surveillance footage, so we were able to obtain that. We looked at the equipment. When I say we, it wasn't me, but it was more the safety person. There was more the expert there, and management. And so we inspected it. We looked at the maintenance records. We looked to see if there's any visible defects to the machine. We reviewed our safety protocol. We looked at whether has John been trained properly on the machine? Has the rest of the team been trained properly on the machine? We analyzed all our data. We went down to look at the root cause. We prepared our summary report, and we did find that the machine guard on that machine was not functioning properly, and John didn't have enough training. So we looked at the training records, and he really hadn't been trained properly on that machine. So that was really the root cause there. So what did we do? So we, of course, got the machine repaired. We provided comprehensive training, not just to John, but to everybody. And we updated our safety protocols and communicated those updates to everybody. And then we implemented regular safety audits to prevent, of course, anything like that from happening again. So, and John was fine. He healed well, and he was very thankful for us for looking into that and for providing further training and fixing the machine. So that's my safety one.
Great, thank you.
Mhm.
All right, so the last bit is Q&A. Before we get started, a couple things. First, the Q&A button, no matter how many times I press it, won't do anything. So I saw 5 people put a question in. If you wouldn't mind moving it over to the chat, that would be great. I've never seen Zoom do it before, but apparently it's testing me today. Next is SHRM PDC. So if you are using this webinar to get an extra hour for your continuing education, you can find the ID right there on the bottom. Audra's and my contact information. And if you want to learn more about Virgil HR or Troop HR, please feel free to scan those QR codes.
Jocelyn, I can pull up the questions. It's
Can you
letting
see
me.
it? Oh,
Yeah,
fantastic.
it's letting me pull up them. Yeah. So the first one here is, how should one professionally address employees who inquire about the disciplinary actions to be taken against an individual they have reported? And I can take this one. This is very similar to what I was just speaking about. I don't recommend giving out every single detail to the complaining party of what was done. Of course, if it ends up in separation, they're going to see that, right? They're going to see that. But there's no sense in saying, this person got a final written warning. And I would just say that this situation has been addressed. We have addressed this appropriately. If something else comes up in the future, if there's repeated behavior, you need to come see me right away so that we can address it. I don't know if you have anything to add to that,
No,
Jocelyn.
I completely agree with you. Yeah, just saying that they were appropriately disciplined. I can't go into details.
Oh, and how do you handle if a complainant tells you not to let the person being accused know? They just want to make you aware. And I can chime in here. So that's going to be really tough, especially if they're naming that responding party. Sometimes the names are going to come up. It depends on the situation, though. All investigations are different. If somebody comes to you and says, hey, I want to tell you something, but can we keep it confidential between you and I mentioned this earlier, as an HR professional, well, it depends on what you tell me, right? If it's something serious and it warrants an investigation or a mandatory report, I have to report it. I mean, it's my job. So I don't know if there's anything else that you want to add there.
Yeah, I think I would just say that maybe really helping them understand what you might have to report or not have to report, but still recognizing that every situation is very different. And so there's always a possibility that you might have to report it. And ultimately it's for their benefit. I recognize people don't want to deal with the conflict or they're scared of retaliation, as we talked about earlier. But if it's not addressed, it's not going to get fixed. And then you just lose a great employee. So
Mhm.
never promising that, but always promising that you'll keep it confidential to the maximum extent possible is the way to go.
Yes, I agree. Next one here. How do you handle? Yeah, this is a good one. How do you handle a he says, she says, and no witnesses?
Mm.
I can chime in, or if you want to take that, I can chime in too.
Yeah, so the he said, she said is always really hard to do. A lot of it does end up revolving around credibility of who you're speaking to, and just the scenario in general. So, for example, one time I had a VP of sales who was accused of sexually harassing someone in marketing. And she came to me, told me what he'd said, and it wasn't egregious, but it was still sexual harassment. So when I went to him, he'd said, "Well, I never said that." Like, okay, well, she's saying that you did say that. So, I just kind of need to get down to the bottom of this. And then he started going off about how our generation was too sensitive, and he just, it makes comments, but nothing like that. And it's like kind of okay, at that point, the credibility is like a little bit out the window. What's difficult is that when it's a he said, she said, I find it to be a little tough to actually move forward with something like a separation. That to me makes me personally just feel a little more uncomfortable. I would instead rather put them on a corrective action and give them training, but Audra, you might have a different opinion.
No, I don't. Sometimes those we're on the same page here. Sometimes those investigations, I agree with the credibility. Looking at their, previous, is there any previous history of this? Who are we talking about here? Is this a repeated? I mean, sometimes you'll have employees who are, um, I don't know the best word to say, but they're constantly bringing up complaints and they're never validated. So you have to take that into consideration. But sometimes in those cases, it just your findings are inconclusive.
Mhm.
Unfortunately, unless you start hearing from other people around the same types of complaints around the same person. But generally, that's going to be, inconclusive.
Yeah,
I
and
have, go
when
ahead.
it is inconclusive, I think it's important to make sure that the person who's come forward knows, like, hey, this is still being taken very seriously. There will be no retaliation. If there is any retaliation that's
Hmm.
happening or any mistreatment, you let us know right away. Um, if you have other evidence that you haven't provided yet, that could certainly help. But
Hmm.
this kind of puts us in a difficult situation because we want to make sure that we're being fair, but we're still protecting everybody involved. So, just kind of reassuring them of that is key.
Yeah, agreed. Last question here, and then there's some questions about the recording and just some housekeeping things. So the last question here. Uh, I have found more often that we are hearing employees use the words discrimination, bullying, hostile workplace environment when they're really talking about either bad behavior, workplace conflict that does not rise to these definitions they're using. Any advice? I have some advice.
Yeah, I do too. Go
Yeah,
ahead.
yes, my clients are coming to us with the same thing. So you're not alone out there. This does happen. It's because employees don't understand the legal definitions. They don't understand the legal definition of what a hostile work environment is. Hostile work environment, I think, is the word that's kind of thrown around the most. This is a hostile work environment when really when you get down to it, it's because someone's personality or maybe they're interpreting something incorrectly from their manager or supervisor. Maybe the manager and the employee aren't communicating well, or it's just a personality conflict. So in those situations, generally, you want to look into it, but it's probably not going to rise to the level of an actual investigation. So you're going to get in there and figure out what the issue is, and then maybe have a mediated conversation between the employee and the manager, or some other, maybe they need more training. They just need to communicate better. So I hear that a lot from our clients. We do look into it, but generally it's not going to rise to the level of a full blown investigation.
Yeah, I'd 100% agree with you. I think training is really key so that they really understand what these terms mean and how it affects them. And then also when you're having those conversations with someone who's coming forward saying, "Hey, it's a hostile work environment," and it's really just like a clash of personalities,
Hmm.
it's educating them as well on what an actual hostile work environment is and helping them understand the difference in action that you would take between a legitimate hostile work environment complaint versus a personality clash. And I do think that mediation is an incredible piece of advice, Audra, because that works wonders in those types of situations.
Hmm. Hmm. Usually just a misunderstanding or just miscommunication. And when you get them together where they can share their story and then their story, and you're just there to, kind of go back and forth and not really make any judgments, but it's just to help them to communicate better. And I have seen those be very, very successful.
Yeah.
Well, those are the questions. There's a couple, there's a questions about if this will be recorded, and I think it is recording, but if it's available for folks after.
Yeah,
Jocelyn, do
so
you?
we will be emailing it out to everybody, let's say Thursday, on Monday or Tuesday. So you'll have the
Okay,
full recording then.
great. And then there was a question about what's the SHRM credit code, and you'll see that right here on the slide.
Yeah, 24D for Delta Y 69K.
All right, well, those are our questions.
Awesome.
Thanks
Thank
for,
you all so much for joining. And Audra, thank you for participating today. I really appreciate it.
yes, yes, thanks, Jocelyn. Thanks, everybody.
All
Have a
right,
good
take care.
day.
Bye.
Bye.